May it please the court, McAuliffe is my name. I appear for the plaintiff.
Thanks, Mr. McAuliffe. Mr. Kuksal, can you see and hear me okay?
I can, Your Honor. Good morning.
Good morning. Thank you.
Good morning, Your Honor. Yes.
Yes, Miss Shu, you're here in person.
Mr. Ansell appearing on behalf of
Mr. Ansell. Right. Now there's a few preliminary matters that have got to be dealt with. The first in time in any event is Mr. Kuksal's application to adjourn the trial. So Mr. Kuksal, why should I vacate the trial date at this late stage?
Your Honor, I believe this morning there's an affidavit that's been prepared by Mr. Ansell, and he has served it on the LSBC and provided it to the court. It's also been filed. In essence, I've been ill since the weekend prior to the 21st of July. I've had serious issue with my left ear. It was actually leaking profusely in the days leading up to the weekend, and I have some mental issues which have exacerbated the I have OCD traits, quite significant ones, and effectively it made me dysfunctional for the period during which the illness persisted. Now this is quite an extraordinary trial. The prejudices to us are quite serious, and the allegations that we're making in terms of the denial of procedural fairness are also quite significant. We've been extremely bold in making those allegations because we've done our work in being satisfied that we have a strong case. There's other indicators of irregularity about the manner in which the case has progressed, which are concerning. And there is no countervailing on the other side. There is a theoretical need for there to be a prompt resolution of matters before the court, which is always the case, but that does not, in any way, come close to the need for making sure that we're not unfairly prejudiced. I can cite a few high court authorities, and I would actually like to, for the record.
You were ordered to file affidavits by, I think, the 12th of July. Did you do so?
So, Your Honor, on the 18th of July, if Your Honor will note, so on the 10th of July, we made an application for Your Honor's recusal.
Yes.
Sorry, I can't actually see the screen very well. It's very blurry. I'm not sure if you can, if it's the same at your end, but...
No, you're very crisp. The image is very good, and the sound quality is very good from our end, Mr. Kuksal.
I can hear things fine, but the image is very... anyway.
All right.
So on the 10th of July, we made an application for Your Honor's recusal.
Yes.
To give some context, I've been working on a model to demonstrate to a scientific certainty that Your Honor has made some serious mistakes in these proceedings, and in refusing to recuse himself. Part of it has involved the use of ChatGPT to demonstrate that the simulation of an impartial observer would definitively concur that, in these circumstances, Your Honor should recuse himself. So...
Sorry, Mr. Kuksal, can I interrupt you? I asked you whether you had filed any affidavits you were ordered to file any affidavits on or before the 12th of July, and I asked whether you had done so.
Yes, and I'm answering that question, so...
Before you give the explanation, can you answer it with a yes or a no?
No, we haven't.
Okay.
But that is not to say that we did not intend to make a case. And it's precisely because we are concerned that Your Honor will dishonestly draw that implication, after denying us an opportunity to address the matter fully, that I'm addressing the matter in the way I am. So, on the 10th of July, we raised an application for Your Honor's recusal. We were at that time preparing to use the methods that I've just highlighted in support of an application to 1. Seek an injunction in the Court of Appeal against Your Honor's continued involvement, and 2. We also wanted to raise a proceeding in the trial court against IBAC for their failure to essentially make a preliminary finding which the IBAC Act obliged them to make within 90 days of having received a complaint. It's notable that they dismiss over 90% something of the complaints overall. I think the number is much higher for judges. I have intimately gone through every annual report of IBAC, and I have detailed statistics.
Mr. Kuksal, I'm not interested in this level of detail.
Okay.
I mean, you tell.
So what I'm saying is that that's what we were preparing for. Now, on the 10th of July, after making the application, we only received a response from Your Honor on the 18th of July to the recusal application. Now, we were confident at that stage, up until we received the response, that there were solid grounds for the application that we had made, and that Your Honor would see that, and failing that it was clear to us that it would be a deliberate exercise in bad faith if Your Honor didn't recuse himself.
Yes.
Then it would not be sensible for us to trust Your Honor to essentially decide the matter in good faith. So, we have then decided, or we had originally thought that if the application was rejected, and in particular, the matter that we thought was quapquarente dies, was irrefutably problematic from the perspective of Your Honor's continuation of your role in this proceeding, is that the ruling that Your Honor made on the 26th of June implied that, based on the presumption of regularity of the Legal Services Board's decision, inferences about the
Look, I understand that point, but you've complained about me taking the view that the cancellation
or took.
the non-renewal of Mr. Ansell's practicing certificate. That is, I have to decide this case on the basis that Mr. Ansell does not have a practicing certificate, rather than allow for the possibility that there might be the decision to cancel it might be challenged in some way. I understand that point.
Your Honor, I think, to clarify the issue from our perspective, it's not as nuanced as the manner in which Your Honor has presented it. For example, a judge who may sentence someone to death would definitively be acting improperly if they shot that person in court. We think that.
But I'm not here to argue that here.
No, but what I'm saying, Your Honor, I think the way in which Your Honor characterized the issue.
This all started because I asked you, have you filed an affidavit? Did you file affidavits by the 12th of July as ordered?
No. But that question, Your Honor, I think.
And this is your explanation for why you have not. That's where we're at, isn't it?
No. But the explanation has not been properly given, or I've not been given an opportunity to explain it properly. The point is that we don't think any judge of a Supreme Court acting honestly would be able to come to the decision that Your Honor has, and we have authorities that directly contradict what Your Honor has said, absolutely diametrically opposite to what Your Honor has said. Court of Appeal authorities, High Court authorities. Some of those authorities have been pointed out to Your Honor.
Yes.
In fact, there's a recent decision of the court in.
Yes. All right. So you say I'm very, very wrong. Pocum size.
No, we're saying that you're dishonest and you're deliberately and maliciously, because you're refusing to accept the law for what it is.
Well, Mr. Cooksall, you know as well as anybody that there's a forum for you to ventilate those issues, and that's the Court of Appeal.
No, Your Honor. The Court of Appeal is for instances where judges make honest mistakes. What Your Honor is doing, in our view, is criminal.
Okay.
We don't think that Your Honor has legitimate authority in this matter, given the fact that the decisions that have been made are so ostensibly in bad faith, that the judges operate an office so long as they act in good faith. That is an immutable aspect of the law. It's been upheld by the High Court. I can cite authorities. And what Your Honor is doing is refusing to accept the statute, and also evading a direct question of accountability. There is a 30% public confidence in the judiciary in Victoria, as per the latest poll. The source for this is 3AB, the radio station. This came out just this week. Earlier this week, the Supreme Court in USA is currently the subject of a number of legislative considerations in relation to the introduction of binding ethical courts. It is atypical dishonest to suggest that judges are incorruptible, or that the system that exists for remedying honest and unintentional errors of law is suitable for a perversion of the course of justice, which is clearly what's happening in this case, from at least my perspective. There is a spectrum. There is a spread in relation to how strongly different people feel about this, but I think I know that everybody on the defendant's side agree that what Your Honor is doing is a legitimate ground to make a complaint to the IBAC, because each one of us has individually made a complaint to the IBAC, which alleges criminal conduct on your part. So, in those circumstances, in fact, I've written a series of questions for ChatGPT, and I have the responses generated. All of that was going to be part of the applications that I made if I hadn't fallen ill. It is undeniably demonstrable that Your Honor has refused to enforce our statutory rights on a number of occasions. You have relied on ex parte communication that you've received from one of the parties to make decisions in a related proceeding that involves the LSBC.
Mr. Cooksall, just tell me what you're addressing at the moment. So we started off by I asking you to I will?
Sorry,
I invited you to present your application for an adjournment in circumstances where all you've produced is 2 medical certificates that do not go into any detail at all about your condition or the effect it's had on you, and you've put no evidence before me at all about your condition or the effect on you. I
can swear.
Let me finish, Mr. Cooksall. I then asked you about the Marquis in terms of preparation for the matter about putting affidavits in by the 12th of July, and you said you hadn't because you had taken the view that I should be recusing myself and was acting dishonestly and inappropriately, and you were pursuing other avenues such as IBAC. So can I take you back to the adjournment application? Bapud and Gol.
Yes. So the issue is this. Only on the 18th we were informed by the court that Your Honor has rejected our recusal application. As a matter of law, and this is not our opinion, but as a matter of law, when a recusal application is made, until it is decided, the judge does not have operational jurisdiction. So Your Honor could not have made any further decision in this matter, or in any matter involving us before deciding the recusal application. That is just an indisputable aspect of the law. So any steps that we took in relation to our abuse or our exercise of rights in respect of Your Honour's exercise of jurisdiction could have only happened after the 18th. 18th was a Friday. It was just before the now. I am stating facts. Your Honour just said, I'm not giving evidence. I'm happy to go on. I'm happy to affirm the veracity of the facts that I'm stating. I think it is, again, unfair to imply that I'm not presenting evidence of sufficient veracity, because in these circumstances I've done what I could have. I have a right to privacy. I have a right to privacy of medical information. There are countervailing considerations where there's an obvious injustice, but it's generally the opposing side that has to raise objections to then open a scenario where further instructions need to be made into someone's privacy. The LSBC has not made any applications or arguments or objections in relation to the objection. There are clear authorities. I'm going to cite some of them. So, Hutchings v. Australian Securities and Investment Commission, 2017, FCA 858. That authority says point blank that if an adjournment is refused in circumstances where the prejudice to the other side wasn't greater than the prejudice to the side that was asking for an adjournment, then there was a jurisdictional error. This is also something that the High Court has said in Minister of Immigration and Citizenship v. S. Lee. What had happened in that case was the tribunal had determined that a party that was asking for more time to produce evidence had gotten enough time, and the High Court had identified that that was not the critical consideration. The critical consideration was whether it was possible for that party to produce a document. All of these authorities are from the period after the implementation of the Civil Procedure Act, and there's authorities including Lachlan v. HP Mercantile.
Mr. Kuksal, I am...
Your Honour, if I could just complete this.
No, but you've moved on to legal argument now. I just want to go back to the narrative. You say that you were legitimately entitled to wait until the 18th of July 2024, because that's when I gave my reasons in the recusal application. So what did you do since the 18th of July 2024?
In distinct words.
You've dropped out for a moment there.
That's the whole point. I have been unable to work since my medical certificate starts from the 21st. My hello?
Yes.
Am I?
You've frozen, Mr. Kuksal, I'm afraid.
Your Honor, might it be best if we just stand down a moment just for that link to be re-established?
Yes. I think we'll stand it down for a moment. I don't know if you can hear me or not, Mr. Kuksal, but you've frozen. If you can, you're frozen. So I'm just going to stand it down for a moment, and I'll see if we can get the link back happening. How's that, Mr. Kuksal? Can you see and hear me now?
Yes, that's better. Thank you.
It dropped out for some reason.
Yes. So, Your Honour, actually, on the 17th of July is when my medical issues had started. In fact, I can produce documentary evidence of my visit to an emergency medical clinic on the 17th of July, and I'm sure they would have maintained notes. My left ear was bleeding profusely, and they refused to intervene at that time because of the concern that it may lead to permanent hearing loss. At that stage, it was recommended that I visit the...
Might have to stand it down. Mr. Kuksal, can you hear me?
Yes.
You dropped out after you said your left ear was bleeding, and they were worried about permanent hearing loss. And then you dropped out.
Okay. So, ultimately, it was recommended that I was at the larger facility that specializes in EMT, in the EMT field, and was advised that I would have to wait for several hours if I was as an emergency patient, and ultimately, I sought to make an appointment to visit the clinic at the later stage. I finally visited a doctor over the weekend, and the issues that I have been experiencing have more to do with causing mental anxiety and insomnia than the inability to hear as such. So on that basis I was given a medical certificate. The doctor initially wanted to give me a medical certificate for a whole week. I asked them to give me one for just 2 days. This was for the period commencing the 21st. Unfortunately, things did not. The sentence about, or the issues that I was experiencing did not subside, and then I had to revisit the clinic the following weekend, and I was then given another 4 days rest. Now again, the care...
Yes. Given that the time for putting affidavits had come and gone, what has it prevented you from doing the medical condition you're referring to?
Sorry, when you said the time is gone?
The 12th of July was when affidavits...
What time are you?
But the...
Yes, but we had applied for your recusal on the 10th of July.
Yes, but so what I'm saying is, what is it? Why do you want the matter adjourned? What is it that you're saying you want to do?
We want to, Your Honor, firstly, we're completely unprepared.
No, just you.
Secondly,
Mr. Kuksal, you're speaking for yourself at the moment. Why are you on?
No, I'm speaking because I have spoken with the other two defendants.
Mr. Kuxel, I'm just hearing from you at the moment.
Yes, but I am addressing the court about what facts I know personally. The other two defendants have relied on me for the preparation of this case. That is,
Well, who prepared the affidavit that Mr. Ansell just put in this morning?
the affidavit that Mr. Ansell prepared was largely an excerpt or was the subset of the affidavit that we were working on for the larger application that we're making against Your Honor, in relation to the Court of Appeal matter and in relation to the proceeding against IBAC. It was a subset.
So who's prepared that affidavit? Are you saying you have prepared that, or Mr. Ansell's prepared it? You're saying that the defendants are relying on you to prepare the matter.
I've been preparing the documents, I've been drafting the documents, and Mr. Ansell and Ms. Xu have been constantly reviewing and expressing their input. Yesterday,
All right, so when do you say you prepared the affidavit that Mr. Ansell has filed this morning?
Your Honor, the document that this was a subset of, we have started working on it much before the, bear with me for a moment. I'm just going through my documents here. So we started preparing the affidavit, the Court of Appeal case, following the decision on the 26th of June. We wanted to clarify a matter that we suspected Your Honor would rule, in accordance with the way Your Honor ruled. So we had started putting in arguments in anticipation of the fact that Your Honor would essentially affirm the decision that was made on the 26th. On the 10th of July, we put the matter more pinpointedly to Your Honor, about the implications of the findings of criminal guilt. That come from a presumption of regularity of the LSBC's decision. What we had anticipated at that stage was that Your Honor would immediately reject the recusal application, as Your Honor has previously, and it was when Your Honor did not do so for 8 days that we were encouraged that perhaps this time Your Honor will accept that there is a reasonable apprehension of bias throughout that arises, which we say is undeniable, and can be demonstrated to a clinical standard. But the preparation of the document had begun around the 26th of June. The document that was sent to Your Honor's chambers on the 26th of June, the letter that I had sent, it largely raises similar issues about the allegations that we're making. That letter was drafted by me. It was also signed by me and it was prepared on behalf of all the other parties. So the document that became Mr. Ansell's affidavit was part of the documents that we were preparing in relation to the appeal, because we had anticipated that Your Honor would rule a certain way. When Your Honor took 8 days, we decided to wait instead of finalizing the application, because A, it was atypical. Normally Your Honor has rejected the recusal applications almost instantaneously or the following day, and the other matter was that on the 10th of July, for the first time, Your Honor accepted that Your Honor needs to address the issue of Regulation 46.05, which, up until then, Your Honor had refused to acknowledge. I knew that there was no justification for it as per the law. So I thought that when Your Honor decided to address that issue, that would ultimately lead to a concession that Your Honor had made serious errors of law which have prejudiced our rights, but unfortunately.
So you downed tools between the 10th and the 18th, because you thought I was going to recuse myself?
Your Honor, we're involved in dozens of proceedings.
Yes.
We have to prioritize resources.
Okay.
It's not that we were not working at all. It's that we had a number of urgent matters, and we were dealing with those.
Okay.
This particular proceeding, we can list the number of proceedings. You can probably see the number of proceedings we are involved in. We have hearings in between.
All right. Mr. Kuxel, what's the purpose of the adjournment? What are you going to do if you get the adjournment?
Well, first of all, Your Honor, I cannot continue with the trial in the current state. I am not in the right mental state, and there's a number of issues, technical issues, with the plaintiff's case which, to an impartial court, would be time-consuming.
Mr. Kuxel, I want you to answer my question.
I am answering the question, Your Honor. I am answering the question and I am being...
Not yet, you haven't. If you got your adjournment, what would you do?
Okay. So, it's, Your Honor, I think you anticipate certain responses, and if they don't match those responses, you. What I'm trying to point out is that the first thing in this proceeding was that Your Honor had given that an amendment to the originating motion would be permitted. Last time when orders were being made in that respect, Ms. Xu had identified.
Mr. Kuxel, I just want you to tell me. I don't want you just talk at me. I want you to tell me what it is you say you would want to do. Are you saying there's affidavit material you want to put in?
Well, firstly, we would write to the LSBC.
Yes. All right.
We would write to the LSBC and get clarification for what the amended originating motion actually is, because the amended originating motion There's been no valid amended originating motion filed in this proceeding as yet. On the last occasion, the one that was filed did not have a provision associated with it. Your Honor had indicated that the LSBC would later have to advise us and the court about what provision they would expect to be relying on. It was our understanding that the process of...
All right. Sorry. So you want to write to the VLSB and ask them about what's happening with the originating motion. All right.
That's right. The other matter is that their case, we haven't even had. They have essentially sought to transform their entire case, and the notice of it. I'm not sure. We've not had... I personally haven't even had a look at the documents that they're relying on. I've been advised by Ms. Sue that they're effectively now arguing that we've engaged in unqualified legal practice, which is a criminal law provision, and there's been no amended originating motion that's been filed about that. There's been no disclosure of evidence that's been done in respect of that. They've to introduce a new ground purely on the basis of informal submissions. It was never identified that they were relying on a criminal statute provision in respect of me or Ms. Shu.
They're relying on the uniform law.
Uniform law is a very wide, Your Honor.
All right, what else?
I mean, the originating motion is a redundant document so that's the first thing. The second thing is that we wish to raise injunctive relief applications against Your Honor for what we say is an attempt to pervert the course of justice. And we note that Your Honor has already determined the matter, in effect. So I think it is again dishonest to first say that the only evidence that can count in this matter is whether the certificate had been issued or not. If the certificate has been issued, then there's no other evidence that can be relied upon to overcome the fact that the LSBC had not issued that certificate.
Yes.
And at the same time, for Your Honor to imply that we did something wrong in not filing evidence. The only evidence we can file in this matter has to do with the manner in which the LSBC is proceeding with their case. We don't even know the full implications of what they're seeking or what they're trying to seek. Because all of those matters are normally raised in the originating motion, and they're clarified well ahead of the hearing. There are directions hearing in which that matter happens. This case has been ongoing since September 22nd, in theory. But the proceeding that they're now contesting only started less than a month ago.
Right.
Without any directions, without any lodgement of documents, and they're sneaking in criminal provision sections for that.
What are the criminal?
Now that's one.
Why do you say they're sneaking in criminal provisions?
Your Honor, they're alleging S10, S11 are criminal provisions of the uniform law.
Yes. They're alleging that you breached the uniform law.
They're summary offenses.
Okay.
Your Honor, I don't know what the distinction is here. They're summary offenses.
All right. So you want the adjournment so you can mount a challenge to the form of the originating motion, seek injunctive relief, and...
Well, we'd have to seek advice as well.
To seek injunctive relief against me.
And we'd have to seek legal advice as well, in relation to what the implications of S10 and S11 are. And
All right.
It is so ridiculous, Your Honor, that I cannot see how they've done this. It would be necessary for us to get some legal advice about whether or not our understanding of the matter is correct, because it is so outlandish for them to argue the case in the manner in which they have, without any notice, without any proper originating documents, without any approval from the court to introduce those provisions. When the proceedings started, those provisions were not relied upon. The court has never actually sanctioned those provisions. At the last hearing, when Your Honor asked Mr. McAuliffe, he said he's not the guy who's going to be finally arguing this matter, and he has no idea what provisions to be relied upon.
Can I ask you, Mr. Cooksall, what did you think the board's complaint was for which they sought injunctions preventing you from communicating on behalf of erudite legal and the like?
I didn't think they had a basis to complain. I didn't think they could come up with a statute.
No.
That's why we've been challenging them. That's why it took them. Your Honor, we've been raising this issue for 2 years. Why did they only come back with a specific provision 2 or 3 weeks ahead of time?
All right.
And in a desperate ploy, why could they not put it in the originating motion? In fact, their lawyer did not know, and Your Honor was far more sympathetic to their lawyer. When Your Honor asked him what provisions they would rely on, Mr. McAuliffe, he's right there, he said he has no idea, and then Your Honor was like, I'm sorry, I didn't mean to put you on the spot there, and then Mr. McAuliffe, this is all in the transcript. But Mr. McAuliffe then clarified that he wasn't going to be the person who would argue the case. At this stage, they would be hard-pressed to find a lawyer that would act for them in these proceedings.
All right.
It has never been argued against me. By the way, Your Honor, I take it that Your Honor didn't understand the context of the application of those provisions, but the questions that Your Honor asked were, again, revelatory of bias, because the—
Mr. Kuksal, it seems to—
No, let me clarify this. This is an important issue.
No. Gonna say, wasn't it obvious that the board was concerned that there were a number of people, you, Mr. Ansell, and Miss—
No, it wasn't, because the law does not allow them.
Can you put Mr. Kuksal on mute for a moment?
No, it was not.
That their complaint was that there was an organization called People Shop Pty Limited trading as Erudite Legal, which didn't have a solicitor associated with a practicing certificate. That was always the concern. And I just don't understand how you say you are sort of, these are my words, shocked and surprised, that they're alleging that you represented an ability that you contravened the act, by either— I don't think they're suggesting that you engage in legal practice, but by your association with People Shop Pty Limited, represented an entitlement to engage in legal practice. Could take Mr. Kuksal off the mute now. Thanks,
With due respect, Your Honor, that is an irrational question because it overlooks the protections that exist in the uniform law that prevent the Legal Services Board from ambushing people with this allegation in this way. Firstly, and I have these sections memorized, by the way, they are required to notify the person the moment they receive a complaint, and without a complaint, they cannot act on any matter. So the Legal Services Board is not an inquisitorial entity, but may, preemptively raid people's offices to see if they are following the law. The jurisdiction for the board to act only arises when it receives a complaint. The moment when it receives a complaint, it is required to notify the party about whom they've received a complaint. I've never been notified of any specific complaint received against me. Neither has Mr. Ansell.
Well, that's not relevant, I think, to this aspect of the adjournment.
It is absolutely relevant, because without a permit, they cannot bring a proceeding. Proper judges have dismissed cases, and I can cite authorities. There's Cahill v. Victorian Legal Services Board, there's Murray v. Victorian Legal Services Board, Dennis v. Legal Services Commission New South Wales. All of those cases were dismissed because the board had failed to notify the party of the complaint. Now, just recently, Your Honor.
When would you—
May I just have one?
No, cool. So what is the duration? I'm not sure about the adjournment yet, I'm going to think about it, but how long do you say it has to be adjourned for?
Your Honor, I would like to make legal arguments because—
No, Mr. Kuksal.
I want to put Your Honor on notice of authorities.
It's a simple question. How long do you say it has to be adjourned for?
I'd say 4 weeks.
4 weeks. Okay.
Yes, and I still want to raise some legal arguments and cite some authorities. In particular, the authority with the citation 2024 WASC 249. This is—
You want to raise these authorities in what context? The adjournment application?
Yes, the prejudice.
All right.
The prejudice arising from the matter proceeding currently.
All right. Mr. Ansell.
Your Honor, I might be able to assist the court in relation to your question regarding the LSB's proceedings, and the issuing of those proceedings, and whether or not I had a practicing certificate at that time. These proceedings—
No, I'm not, but I'm just dealing with Mr. Ansell. You say you want an adjournment.
Yes.
All right. The claim against you is quite different to the claim against Mr. Kuksal and Miss Shu. Why can't we if I do adjourn or put the claim off against Mr. Kuksal and Miss Shu, why can't I proceed the claim against you?
Yes. Well, Your Honor, the way in which we prepared this case was based on the fact that Mr. Kuksal has obviously had complete involvement of the whole matter all the way through.
You say that's obvious, but Mr. Ansell, you've put in extensive affidavits and the like.
Yes, I have put in extensive affidavits, but there have been a lot of those not in relation to the affidavits I've prepared. But what I'm saying, Your Honor, is that my involvement in this matter has not been consistent, and I've said that in the affidavits.
You're a defendant to this matter, okay?
Yes.
You didn't put any affidavit material in by the time ordered.
Yes, Your Honor.
Now you weren't unwell.
No, Your Honor. But I have a reliance to a certain extent on the material and Mr. Kuksal's ability to provide data. He has extensive data systems which contains the information. I don't really know how to access those.
What about a submission that you were ordered to put in?
Yes, Your Honor. Again, it's a situation that I have worked with Mr. Kuksal and Ms. Shu in preparing my matters as well. We were hoping to proceed, Your Honor. The problem has been that Mr. Kuksal certainly has been unwell, and we were hoping to proceed. However, given the fact that he has still been sick right up until the last moment has defeated that purpose and—
So what steps have you taken in the last month to get ready for this trial? You personally?
Your Honor, Yes, certainly.
Can you identify a single step you have taken personally to be ready for the trial?
Yes, I have been in conversation. I've been with Mr. Kuxel and Ms. Shu virtually every day in the last month. That includes weekends. So I have continual discussions with Mr. Kuxel in relation to this matter, and also strategy in relation to the matter. We discussed the preparation of documents quite extensively. I have input into that. Your Honor, my situation is that I'm a suburban lawyer. I don't have the necessary ability to argue very complicated matters before the court. That's not what I do. I do wills. I do conveyancing. So I have never actually been in practice to litigate or argue these sort of matters extensively before the court. So there has been a reliance in the preparation of the material in conjunction with Mr. Kuxel, and his late withdrawal from the matter has prejudiced my ability to actually properly proceed.
So what did you think was going to happen? I mean, as at yesterday, nothing had been filed, no affidavits, no submissions. An email comes in yesterday from Mr. Kuxel saying, "I've been sick."
Yes, I was getting obviously concerned about the matter, but there has been a lot of work done in relation to, as Mr. Kuxel talked about, the affidavit had been preparing, which we took a lot of the material from, for the affidavit I prepared today. So there has been a lot of work done. Mr. Kuxel has a great why.
Well, when was that work done?
It's been done progressively over the last month, as Mr. Kuxel indicated, in relation to the preparation of the affidavit for the Court of Appeal matter.
And has that preparation been going on up until yesterday?
Yes.
Despite the fact that Mr. Kuxel tells me he hasn't been able to do anything for 2 weeks?
Mr. Kuxel hasn't been able to participate as he normally would. Mr. Kuxel has an ability.
Mr. Ansell, what is it? Right, you tell me you don't do anything without Mr. Kuxel. You tell me you've been busy working on the affidavit up until recent times, which was an extract of which came out this morning. And you tell me Mr. Kuxel's been incapacitated for the last 2 weeks. So what is the situation?
It's a mixture of all of those issues, Your Honor. I've spoken to Mr. Kuxel. I've been in contact with Mr. Kuxel.
So you?
I haven't, as Your Honor will.
Have you been working with Mr. Kuxel and Ms. Shu basically all day and including weekends? Not all day, but every day and on weekends for the last month, in preparation for the various civil trials?
Your Honor, I certainly couldn't say I've been working every day. I've had other commitments to do, but a significant amount of my time has been involved with this matter and Mr. Kuxel.
All right. All this month, all through July?
Yes, Your Honor. Certainly not every day because there are other things I've had to attend to, obviously.
A minute ago, you were supportive of Mr. Kuxel saying that he's been incapacitated for the last fortnight.
Yes. When you talk about Mr. Kuxel being incapacitated, Your Honor, the simple fact is, he's not been able to produce the amount of work that he normally does. He normally works 20 hours a day and has not been able to do that. He does that.
So how many hours a day has he been able to work, do you say?
I haven't kept a complete check on the number of hours, but I know that he's Mr. Kuxel.
But you tell.
For the last 2 years.
I know none of this is on evidence, but you tell me he's been working this month on his matters, but not 20 hours a day.
Certainly. His illness or the problem with his ears has severely restricted his ability to work in the matter, Your Honor. That's been clear with my, contact with him over the last 2 weeks, and the issue for me is that in relation to presentation of the material, yes, there is a reliance on Mr. Kuxel to do the presentation, and that if the matter proceeded, that would be a prejudice to me.
Why? What adjournment would you? I mean, Mr. Kuxel can't argue your case for you.
No, I certainly understand that.
Your case is different to Mr. Kuxel's.
Yes, but, yeah, I.
Because you had a practice, you're a lawyer.
I understand that. But there are still a lot of similar arguments in relation to which we would still be.
Name one. Name one similar argument.
Oh, well, certainly in regards to the fact that these are going to be criminal proceedings, because criminal charges have been brought against me.
All right.
So I would be arguing, for example, that the notice to admit is not relevant to me because it's in relation to they've asked me questions in relation to criminal proceedings.
Right. When did you decide you were going to argue that?
Oh, there was, I think on review of the notice to admit, Tuesday or Wednesday, Your Honor.
Yes. Right.
I mean, that was when
But on the merits of the high point against you would seem to be the production of the bill of costs, where it seems that you have completed a bill of costs at a time when,
Your Honor,
your practicing certificate had been cancelled.
I'm not arguing that there's a bill of costs. The argument in relation to the bill of costs would be what it actually incorporates. Because the costs that have been claimed in the matters that have been on when I've not had practicing certificate relate to the preparation of transcripts and the overseeing of the transcripts. So it's a question of those of disbursements. There is a little bit of an issue.
Well, that's all material that is entirely within your knowledge, isn't it?
Yeah.
I mean, what you were in fact doing, what you yourself were doing or wasn't doing, is something that you know.
Yes.
So how can you say that it's up to anybody else but you to put in whatever affidavit material you wanted to put in, and whatever submissions you wanted to put in about that?
Yes.
I mean, what I'm saying is, how can you hide behind Mr. Kuksal on that?
Yeah. Yes. I'm not hiding behind Mr. Kuksal, Your Honor. I'm saying that, premef.
Well, you're telling me that you couldn't do anything because Mr. Kuksal. You rely on Mr. Kuksal to prepare documents.
I rely on Mr. Kuksal in relation to the amount of data and the documents and the keeping of records and all the material in this matter.
Yes.
I don't have the ability to maintain the data references and data banks that he has in relation to the, as Your Honor would appreciate, there's thousands upon thousands of documents. I haven't got the ability, computer skills or otherwise, to be able to work through that sort of volume of documentation without assistance.
So what do you want the adjournment for?
For the same reasons, Your Honor, that Mr. Kuksal has reiterated, that there will be, we're making an application to the Court of Appeal in relation to an injunction. We also need clarification.
You've been talking about an application to the Court of Appeal for weeks and weeks and weeks and weeks.
Oh, I know. Your Honor, it's simply a fact that we are very limited resources.
All right.
And these are extensive claims right across the board. I mean, we're talking a number of matters. The information and material we've obtained over the last 2 years, of which this matter has been going, is significant. I certainly have an issue in relation to what was raised about the originating motion, the fact that we really don't know their cases yet. That certainly is a matter that needs.
What did you think their case was against you?
So, pardon?
What did you think their allegation was against you? I mean, there was a big argument in court where it was said that their case is misconceived because, in reality, you always did have a practicing certificate because.
Your Honor.
No, let me finish. The argument that Mr. Kuksal put and you adopted was that, sure, your certificate had not been renewed, but you were challenging that.
Yes.
And you were going to successfully challenge that.
Yes.
And that would have the effect that you always did have a practicing certificate.
Correct.
Therefore, what you did was okay.
Well, exactly right, Your Honor. What would...
All right. Now their argument is, what you did wasn't okay because you didn't have a practicing certificate. Isn't that always how you understood their case?
Your Honor, the argument is that they had no jurisdiction. We argue that they had no jurisdiction in relation to the determination they made in respect of my practicing certificate.
All right.
Okay. So, and that's been our argument from day one.
All right.
They did not have the jurisdiction.
But was it your case? Yes, I practiced as a lawyer, but when you look at it properly, I did have a practicing certificate because they acted without jurisdiction.
Well, Your Honor, what we say is...
Was that your argument?
Yes, Your Honor, because
Okay. Now how can you say that you didn't know that their case was that you were engaging in legal practice without a practicing?
I'd like to formally register my objection, Your Honor.
No. Put Mr. Kuksal on mute, please.
Sorry, could you repeat that, Your Honor? No, just if...
No, I lost it myself.
I had...
Okay. There was a lot of argument before me.
Yes.
To the effect that the case was... One of the problems with the board's case was that it was going to be argued that their decision not to renew your certificate was going to be set aside in due course.
Yes.
And a result of that would be retrospective in the sense that it would then be that you always had a practicing certificate.
Yes. The uniform law says that, Your Honor.
Yes, that's right. In which meant that the case against you would fail.
Yes, Your Honor.
All right.
Because their decision would be nugatory, yes.
Yes. Okay. But that carried with it, didn't it? An acceptance that, if you didn't have a practicing certificate, if you were wrong, and, in fact, you didn't have a practicing certificate, then the case could succeed.
Yes, Your Honor. That was always the argument. The argument would be I prepared.
So it follows from that, doesn't it, that you always knew that the case against you was that you were carrying on legal practice, engaging in legal practice, without a practicing certificate?
Your Honor, I don't know if I should be answering that question on my feet at the minute without time to consider it.
Well, you're applying for an adjournment.
Yes.
On the basis that you don't know their case and you haven't had time, and Mr. Kuxel has been unwell. And I'm saying to you, you've got to persuade me that you didn't know. And Gazara Banat Sakti.
Certainly, Your Honor. I'm saying that.
What your case was. The case against you was.
I'm certainly saying that in regards to their originating motion in relation to this particular matter, right? Okay? That their case has changed, and we don't know on what basis. They're supposedly using a different section of the Uniform Law, and that applies equally to me and the others.
How has the case against you changed?
I'm saying the case is changed because of the issue of the injunction, which this is all about, is one where the initial proceedings and the sections that they rely on or relied on have changed. They've gone to amend their proceeding. Now, they've not put forward the actual material in relation to that but they still haven't. The court hasn't approved any amendment, so that's still part of this proceeding.
I gave leave. I mean, they've filed the amended originating motion, haven't they? Yes, February.
I was under the understanding they hadn't.
They filed it 5 months ago.
Yes, but I'm on the understanding that you hadn't made any. That there was, I think you were going to look at it or hasten approve it, which I don't believe that you've done.
So what did you think was happening with the originating motion, Mr. Ansell? Did you think it was on foot or not?
Well, until we know exactly what they were arguing, it's a bit hard to actually say, Your Honor.
What did you think the trial was going to be on that was set down for hearing today?
Well, that's actually one of the issues that we've raised in respect of that matter.
No.
And then the issue.
What did you think the trial was for? Did you think it was the hearing of the amended originating motion today?
No, Your Honor, the issue is yes, certainly. In regards.
So what are you saying about this? I can see Ms. Hebergi's writing you notes.
Yes. No, she's just giving me a date. The date was when we only received their submissions, which was on the 22nd of July.
Right, yes.
So we've been trying to ascertain, within that time, exactly what their submissions are, and considering those and giving Mr. Kuxel.
Well, the submissions I've got from the board are dated the 19th of July. Did you say you didn't receive them until the 29th?
That's the note that I've got here. Yes.
You didn't receive them until the day before, about 2 or 3 days ago.
Yes, the 22nd of July. That's.
Sorry, I thought you said the 27th of July. Yes.
Yes, 22nd.
Sorry, I thought you said 27th.
Sorry. No, I said the 22nd.
Yes. So that's the Monday.
Yes.
Yes. And you've read the submissions.
Yes.
And you haven't put in a submission in response.
No.
And I might have asked you this. So if you do get the adjournment, what do you propose to do with it?
Well, there's the issue of the appeal, Your Honor, in respect.
So you'll run and get an.
Yes. I know that it's been raised before, but I think that that's certainly something that's, again, could happen probably if.
The appeal could.
Mr. Kuxal hadn't taken ill.
Right. So you run and get an injunction from the Court of Appeal to stop the trial going ahead, or to make me recuse myself.
Or have the Court of Appeal determine the matters that we say that Your Honor has erred in.
Which is the recusal?
Yes.
Yes, well, if you can persuade the Court of Appeal that I was wrong not to recuse myself, then whatever decision I make in this trial would fall away. So why is that a reason why I shouldn't push on? I mean, now that you're here.
Well, the reason which I'm putting forward, Your Honor, is that as of this moment, I'm prejudiced in the proceeding forward under this trial because of the fact that I've had under-resourced to be able to get everything done within time. I've got an issue with the fact that the way in which we've prepared the matter has been, if the injunction with Mr. Kuxal and relying on his databanks and material that he has, and that has will cause me prejudice if I had to proceed with the matter at this point in time, Your Honor.
So what you're really saying, you can't really tell me other than the appeal. You can't tell me that you want to put in affidavits.
Your Honor, I think that.
And what evidence would you want to put in?
Your Honor, can I just refer to the affidavit this morning?
Yes.
If I might just.
No, yes, of course.
Yes.
All that says is that you want me to recuse myself. You want to adjourn it, and you want to add the Attorney General and the Victorian Equal Opportunity and Human Rights Commissioner to the proceeding.
Yes, that was.
Is that what you want to do?
That was the bit that I was going to refer to, Your Honor.
Okay, and why would they be added?
Because of the issue in regard to the question of human rights issues. Once they're raised, that they should be advised of those matters.
Yes. You want to force them to come along even if they don't want to. Have they had.
Well, it's a question of law, Your Honor.
So you've served the notices on them?
Not as yet, Your Honor. No.
No.
A Form 12s or S12s are.
Yes. No.
Yes.
So what you're saying is, you want time to finish preparing those notices and to serve it on them, and for them to think about it and then for you to add them along. Okay. And tell me what the purpose of having them added is. How does my decision on whether or not I should make an injunction preventing you from engaging in legal practice, whilst you don't have a practicing certificate, is going to be influenced?
Well, Your Honor, I would argue that.
I haven't finished, Mr. Ansell.
Sorry, my apologies.
The relief sought against you is an injunction that I prevent you from engaging in legal practice so long as you do not have a practicing certificate. You are opposing the grant of that injunction.
Yes.
I'm not precisely sure the grounds on which you're opposing it, but be that as it may, you're saying that somehow I shouldn't decide that until the Attorney General and the Victorian Equal Opportunity and Human Rights Commissioner are part of this proceeding.
No, Your Honor.
Now, why is that?
It's not only that issue in respect of this matter, Your Honor.
But I want to focus on that issue. Why should I delay the hearing of that argument and the application for that relief against you until the Attorney General and the Victorian Equal Opportunity and Human Rights Commissioner have been added to the proceeding?
Your Honor, I think, asked me what other matters that we were going to consider. That was one of the other matters I was going to consider.
No, it's correct. That's true, Mr. Ansell.
Yes, and, it's not the sole matter, Your Honor, but it was a matter, so I'm not saying that that's the sole matter. My issue is that right as we stand at the moment, is that if we were proceeding, then my position would be prejudiced.
All right. Because you're just not ready to argue it. Safahida.
For a number of reasons.
But the real reason is, Mr. Kuksal hasn't been well enough.
We've done everything over the last 2 years collaborative in respect of this.
In reality, is there any reason you can put forward as to why you are not ready to argue this case today, other than the fact that you say Mr. Kuksal has been unable to assist you in the last fortnight?
Well, also too, in regards to the fact that we only got the submissions, recently and for their position. That's something that I've had to consider, and it's been, as I said, very under-resourced, Your Honor, and it's just been difficult.
Yes. All right. Ms. Kuhl.
Yes.
Thanks, Mr. Ansell. Is there anything you want to add?
Yes, quite a lot. So, I will also make a German application, and so I will start by answering the question about what was your understanding of the case was about. So, I have been understanding this case until the 22nd of July this year, that this case brought by the Legal Services Board is about, that we are not following the instruction given by Mr. Rapke. I say that is because that is what their original case was about, and what's in their original legal submissions.
Yes. Okay.
So,
what did you think when you saw the amended originating motion that was filed on the 23rd of February?
There it's the same against me. The same. Okay.
5 months ago.
It's the same. I don't know. I do not know about their new legal ground. I have been asking consistently every single hearing, when I'm before Your Honor. I've been asking them the question. When Mr. Rapke is gone, why am I still here? My understanding was that I did not, or that Mr. Mr. Ansell did not follow Mr. Rapke's instruction. He gave some instruction to us, and we didn't follow that, allegedly. That's why they're seeking an injunction against us.
That's right.
Sorry. Let me please finish.
No, let me just on the 5 months ago.
Yes.
They filed an amended originating motion in which they were applying for an injunction against you, preventing you from sending emails from the various eruditelegal.com.au email addresses, or sending correspondence purporting to be from PeopleShop, Pty Limited.
That was the same.
Okay. But what they're trying to get an injunction to stop you from communicating in a way that associates you with Erudite Legal, or as a law practice?
Well, first of all, in their submissions for the amended originating motion, they did not explain to me what their ground is. They've only done that 10 days again.
Yes.
The submissions filed by the LABA, by the Legal Services Board in February, or before that, they did not address me about any of the new grounds.
I understand your point that you hadn't, so you say that you now, but...
That was my understanding, and I've been asking consistently, even after the originating motion is amended. I'm asking why, since Mr. Rapke is gone. Why am I still here? Was there a new ground? I've even asked that question if I can refer Your Honor to the transcript.
Yes. In this proceeding?
Yes.
Do you want me to try and see if I can find it?
If that for June 24th.
Yes, I have that. What page?
Yeah. So I will just need 1 minute, sorry. So, P35 I believe. Page 35 from line 2. Honor.
Yes, I can see that, so you're saying they should be.
So,
You want to know what section they're saying they're relying on?
yes, because I've explained here previously it was 364. Basically, they're saying that's not following the external instructions is an offense to against the uniform law. That's what I have been always understanding the cases. And Your Honor will remember every time I'm here, I ask the same question. Why, since Mr. Rapke had ceased his appointments, why there is still an injunction going on?
Yes.
That was because my whole belief about the case, what it is about, was based on their original legal submissions. So after their originating motion was amended, then I obviously have been continuing asking this question, yes, is there a new ground that they're relying on? So that's P36. So around line 18, if Your Honor can go there. Page 36. So I said, I understand previously was 364. Now I want to know if they're still relying on it.
Sorry, yes, I've got it.
Or if there is another section they have alleged that we breached.
No, yes.
So I honestly do not know.
So what you say? Your argument then is that until you got the submissions you didn't understand that it was Hess 11 of the Act of the Uniform Law that you're relying on.
That's absolutely yes.
Alright. So, now that you know that, what do you want to do?
Well, I just know.
Is it just a matter that you needed?
It was just clarified to me after 1 year.
Alright. Okay.
I've been asking.
But is it the position that you need a bit of time now to reflect on it? Is that the basis for you?
Yeah, no, not just a little bit of time. I think I will need more time because I am a lay person. First of all, I'm Chinese. English is not my first language. I'm not very good with law and the like. So I will need time, yes. Bias.
Miss Xu, your English is excellent, and you're clearly a very intelligent woman.
But I have no legal background.
Okay.
I have not studied law in Australia.
Right.
I've been only living in Australia for 7 years.
Okay.
So, no, not very good.
All right.
That is why I will need more time, now that there is new allegations that's made against me, and very, very newly clarified and justified after, again, 1 year of me asking the question every time I'm in court. I will need.
Well, here you are. You've taken it to the 4th of June 2024. They had made the amendment in February. You can't.
I've been asking.
You told me you've been asking for a year.
Yes, since the first time. The first time I was before Your Honor was the 17th of August 2023. I've told Your Honor that was, I think, M's ass.
All right. And whether that doesn't matter. I understand and I can see some strength in your point, that you weren't aware. The focus on S11 and how that operated wasn't made clear to you until recently.
It was not just not made clear.
Okay.
I didn't know. I was taken by shock.
Yes.
I do not know.
All right.
And also I think is a criminal offense. So
they're not seeking criminal sanctions. But all right.
Well, but still.
All right. Now thanks, Ms. Kerr.
I'm sorry, Your Honor. There will be a few other grounds.
Yes.
Which I would like to, so that those are from the exchanges previously before the court that I also want to address. The first question is, why did you not file any affidavit before the 12th of July?
Yes.
So, for myself, the response will be that I have sent an email to seek extension on the 26th of June 2024.
Yes, but that's not an answer. Why didn't you?
So I have sought an extension.
Yes.
But Your Honor had not responded.
Okay. So why didn't you file in accordance with the order?
Yes. That is because, if I can just read the email that I had sent to the court. Sorry, just give me 1 second. So I said, I request the court to extend filing deadline for Order 2,346,710 of Gorton J. Order, dated the 4th of June 2024 to 2 weeks after the plaintiff filed those submissions. So in Your Honor's decision, Your Honor said that they must point out what sections they're relying on. That was in this proceeding. Your Honor told them that they must identify.
Yes.
But Your Honor gave them until the 19th of July to do that. So Your Honor's order had given me almost no time to understand the case. And again on the 4th of June 2024, I said I don't know if they're still relying on that section or if they're relying on new sections. Now new sections had been relied on, old ones have been abandoned. So that's why on the 26th of June 24, I've sent an email requesting Your Honor to extend the filing deadlines to until after their submission is filed.
So
after they have clarified their legal basis.
So what time did you seek the extension until?
2 weeks after they filed their submissions.
All right.
That's what I said, and Your Honor, I I will raise a small complaint about this if that Your Honor in your judgment you say that was so. In your judgment you said that at 2:01 p.m., Ms. Xu circulated an email asking for various things to be done in the event that I don't recuse myself. And my complaint is that Your Honor didn't even list what I have been asking. So what I have been asking was that so I can only make the application for abusive process and all the other applications after I understand their case. I've been telling the court and them that I don't know what the case against me was about. Rapke is gone, why am I still here? Every time I'm here I'm asking the same question, but there hasn't been any response, so I was wondering if there is new grounds.
Well, those emails you sent were sent after I'd announced I was about to hand down my decision and are given at a time at which I was going to do it.
Yes.
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 Right.
But is still before we are due to file the documents, but…
Yes. Yes. No, that's all right.
Because so what? I can't do much. I have to wait. I have to wait until them clarify what their new ground is. I didn't know.
Okay.
So until the 22nd of July, which is when I have received their submission with the new grounds, I am unable to do anything. And they have also filed a proper basis form, which is something that people do when they commence proceeding. So, it's like S4, 4A and 4B. So it's, early stage.
All right.
So to me, it's the start of a proceeding. Because, I know how criminal proceeding is started when they accuse people of doing something. They put the section of the Crimes Act where, what they're breaching, they've put the section in, then they say this is what you are doing. Identifying the section of the act and what you are alleging people have done wrong is the first thing you do when you start the filing of the proceeding in the court, and then you serve it to the defendant, and then you say, this is what you've done wrong. I have not been provided that until 10 days ago. So I'm not sure how I can explain the prejudice against me. I am unable to file affidavit. I don't know the allegation against me.
Okay.
What that is. So that's why I can't.
Do you want to put in an affidavit?
I would, Your Honor. I will need to consider the new grounds still, and I will need to see if I can seek legal advice because those are new grounds. I am not prepared. I do not know about that at all.
Are you going to engage external lawyers?
I would start looking for lawyers to get advice because it was not.
No.
This was not told me before. I don't know about this before.
All right.
Sorry, just.
Yes.
And then, obviously, I also want to join the other defendants' submissions in filing the Form 12 about notifying the Attorney General and the Human Rights Commissioner, because I said that what they have done is of my human rights by putting criminal sections in a civil proceeding and pushing me last minute with the new grounds. After I consistently been asking them, what am I doing here? And I really want to read out the transcript that was between Your Honor Mr. McAuliffe, and Mr. McAuliffe was telling the court that he was not sure, and he said that he will have it justified.
Is that the same day as to the…
Yes.
I've got that up.
And that's at, I think, P3.
Page 3, at the beginning?
Yes. So basically Your Honor was, so what do you have to prove to get the relief? And Mr. McAuliffe says, I have to.
Sorry, what line are you on?
Sorry, what line are you on? Sorry, give me 1 second. So I think that was from P1. So can Your Honor find the… I have to apologize, Your Honor. I wasn't prepared to answer the question.
Do you have the transcript there?
Sorry, just allow me 1 minute.
Yes, I have that now, actually.
Yes, so, Your Honor, at P1 you say to Mr. McAuliffe, I want to touch base with you first, and then P2, Mr. McAuliffe says I have to apologize. I wasn't prepared to answer that question. I think the test would relate to those referable to a final injunction test, and that would be evidence necessary to show that.
Yes, I can see.
So, basically, my allegation is that on the 4th of June 24, Mr. McAuliffe was appearing for the LSB, and he himself didn't know what the basis was. And my allegation is if they knew, they would have told us. They've come up with the new excuse or the new grounds much after.
All right.
Because, they will not have a good intention again, because Your Honor gave them the timetabling to file the submissions was prejudicial or, I will say, biased against us. So
you say you needed another week to get the shares, you needed 2 weeks after theirs.
2-4. It was for the application for abuse of process, and all the range of things before Your Honor had, and the security.
All right.
Sorry, it was… What's the name? Cost. Protective cost application. So, again, my case was at… I do not know the case against me. I have to see their submission first before I can do anything. Why adding new grounds and adding new sections that they are alleging that I have breached? They have, virtually, they started the new case, and I genuinely did not know what was the allegation.
Yes.
So I am put in a very bad position again with me not being able to seek legal advice. It was just very late in the stage. It's only 10 days that I have until I came here. So in the normal course from when the case started until when you go to trial, I think, if I can, I will ask for a 3-month adjournment.
Okay.
And again, this is really not my fault because I have been asking. That day, I have asked Your Honor to direct the Legal Services Board to point out what the section was, and then they couldn't even tell me, the 4th to the 4th of June. How can I prepare?
Yes.
My allegation is that they didn't know. They have come up with new justification after I had been asking. And it was because that was Mr. McAuliffe. Mr. McAuliffe here. He has formulated the submissions. So, on the 4th of June, he didn't know. On the 19th of July, he knows. That means that he prepared that submission. He probably, or, after consultation of the clients, he came up with the new section.
So, a long time ago now, Justice Forbes made an injunction, restraining you from using erudite legal, or a .com type things.
Yes.
And what they're really seeking now, aren't they, is that the form of the interim injunction be made a permanent injunction.
I understand that.
Alright, so why did you think the interim injunction was being made?
It was because they are alleging that Mr. Rapke had given me an instruction not to send emails from those email address.
Okay.
And I
Understood that.
allegedly sent it anyway. That's why they said I have breached sealing of FINAN 64.
Yes.
That's what I have said in court on the 4th of June, and also, I have pointed out in my affidavit on the 4th of June, I think, because that was in the original legal submission by their senior counsel at the time.
Shag moss, alright.
That was prepared by them. That's why I understood at that point.
Thanks, Miss Coe.
Sorry, one more matter that I want to address, was that about why the court should not hear the case against Mr. Ansell alone. So first of all, this is one proceeding. This is not 3 proceedings heard together.
Yes.
There are 3 defendants. The facts are interconnected.
Why do you care?
I do, because if there is any findings made against, or any finding of facts made against Mr. Ansell, that can potentially affect our case. Whatever it is, this is one case. There is no reason why it should be separate into 3 different cases. And we have been preparing material together. The argument, well, Your Honor made.
Do you accept, though, that you're in a different position because no one's suggesting that you're a lawyer without a practicing certificate?
They are. They are saying that I.
No. Well, they're saying in reality that you don't have legal qualifications as I understand it.
Yes.
You were never the sort of person with a practicing certificate associated with erudite legal.
Yes.
You were a director.
Yes. But still, this is a one proceeding. It was one proceeding that was originally made against for a different defendants, and then they've used the one affidavit to, for example, from the beginning, Mr. Ben Davidson swore his affidavits towards.
I accept that it's one proceeding.
They use the same affidavit. They use the same submissions.
Yes.
They're in the same proceeding against 3 people.
3 different people.
3 different people. And they're not 3 separate proceedings. If they withdraw their proceeding today and then make 3 separate new applications, then, they can be heard separately. But we're not 3 proceedings heard together.
They're alleging that you and Mr. Coxall breached S11.
Yeah, I just heard that.
They're alleging that Mr. Ansell breached S11, but their principal case, it seems to be that Mr. Ansell breached S10. They're not alleging that you breached S10.
But still, we work together. Maybe when he's breaching and I am breaching the thing, I'm copied in with each other. So if there is any finding of fact, it will affect me. And we prepared the submissions together. If this is one case. You can't just separate it and, I think, I have sued I sued the State of Victoria and Legal Services Board and IBAC together. I've seen them, talking to each other all the time, passing notes. They can help each other, why can't we? And I don't know if they've been exchanging legal submissions or whatever, but it will be a prejudice because the case originally was brought against all of us. You can't just separate one. That will show prejudice because Your Honor will think that okay, maybe, this case seems more strong against one of the person, and then let me just, punch him harder, and then the others, because the main guy is done, then, the others I can just kick it, and then they will also be, because if there is any findings and a decision that's already made against one, then the others can't challenge it, and again it's the same. It's one proceeding, it's not separate proceedings.
I mean, one of the allegations, just testing this, one of the allegations against Mr. Ansell is that he's witnessed people swearing affidavits when he didn't have a practicing certificate.
Yeah. He might witnessed my affidavit. I can't. I don't know.
Okay.
I can give evidence.
That he didn't?
Sorry?
I mean, one of the allegations is going to be against Mr. Ansell. You witnessed affidavits when you didn't have a practicing certificate.
You don't have to.
And suppose I made a finding that he had witnessed affidavits when he didn't have a practicing certificate, how would that prejudice the defense of your case?
Well, first of all, again, I've just known the new allegations against me just now. I don't know whether, because I know the case so far that I understood is that on the prepared by section on the train track, they said that I have put something that I'm not entitled to, allegedly. So if
It's a slightly different question.
They can be arguing or complaining about the same document.
Yes.
So if you...
But they're complaining about Mr. Ansell's conduct in relation to the document, not yours.
No, I think what they're saying is that because in the prepared by section I put something they say I am not entitled to.
Yes.
That's why I'm doing something illegal. And that's the same document.
Yes.
So, if findings of facts against one person can affect mine, because then Your Honor can say, okay, you can't put that name in Mr. Ansell's case, and then I will be nowhere to argue against that finding. I will only be able to appeal that decision, and against someone else.
All right.
But how can I, because in one document, if they, for one affidavit for example, they are complaining me for doing this, complaining him for doing this and that, then this and that is found, then I'm done, so
Why does that follow?
Because they can complain that Mr. Ansell also certified that name was put there, so if that finding was affirmed or there is a finding made against him for that, then I am also guilty of putting a name that they say I'm not entitled to, because it will be on the same document.
Yes.
But, and then, what can I do? Like, on the gallery and say, sorry, can I raise objection?
Yes. But suppose the argument against Mr. Ansell that proceeded was only the argument that he breached S10, that is, not S11. So suppose I decided to deal with the S10.
It's not necessary.
Breaches first.
It's not necessary, Your Honor, because...
When you say not necessary, it's just...
To separate the case.
Stepping forward. It might not be necessary, but at least it achieves something, given that we're all here.
Is Your Honor suggesting that there is a possibility of proceeding with the case?
Against Mr. Ansell today, yes.
Can I just request a short...
No, you can't. I want to speak to Mr. McAuliffe.
Okay. I'll just go back to the same argument that...
When you're finished...
Sorry, I haven't been heard, Your Honor.
Put Mr. Kuxell.
But I haven't been heard about this issue.
Put Mr. Kuxell on mute, please.
I do want to say that Mr. Kuxell can be affected by not responding to Your Honor's suggestion that Mr. Ansell can be tried today.
I might come back to Mr. Kuxell on that.
Yes. So, what I'm saying that is, Your Honor, no, there is no disputed fact that we have prepared the case together, and the resources are tied together. I may know dates, I may know some other facts that's, more fresh in my mind that I am able to assist Mr. Ansell. If he, just forgot.
You've been able to assist Mr. Ansell for months.
Yes, but if I'm left out, Mr. Kuxell left out, and then Mr. Ansell appear him alone, he will not be able to, for example, cross-examine the deponents of the affidavits for, the people who, and again, there will be it is. I've always saying this, although I'm not a legal practitioner, I've not been having too much legal knowledge, but I've seen defendants of completely separate people. They're just being sued together, they've been passing notes, passing submissions, ideas all the time. They can help each other, we can as well.
All right.
And again, if any findings is made against Mr. Ansell, there's a real possibility and prejudice that it can be then prejudice against us. And we will be left no chance to argue that, only have to appeal. And that I will mark as an appeal ground if Your Honor is not granting that.
Yes, all right, thanks Mr. McAuliffe. What do you say I should do?
Your Honor should refuse the application for an adjournment and proceed today against all defendants.
What about Ms. Yu's point that it was only just over a week ago that she was aware that an allegation was made that she was in breach of S11 of the Act? The uniform law, rather.
Well, I'm not sure how that can be sustained on a number of bases, and I'll take Your Honor through them if I have the opportunity. But just to start with a very minor correction, but might have some significance, the submissions were filed on the 19th of July.
Yes.
And an explanation was provided on the 20th of July when they were served on the defendants. And the explanation that was provided in the email, and I certainly can call evidence about this if required, is that my instructor's emails were affected by the CloudStrike server issues.
I'm not issues in attributing blame.
No, I accept that, Your Honor. And it's a matter of, firstly, that I understand that the reference to the 22nd of may be a reference to the Monday when they accept that they would have received them, as it being a business day.
So you say they got it on the Saturday or the Sunday?
Indeed. And so that's the first matter. The second matter is in relation to the amendments to the originating motion.
Yes.
As Your Honor will see from the proposed amended originating motion, firstly, as Your Honor knows, that application was made, and Your Honor made orders on the 19th of February, and that proposed amended originating motion was filed on the 23rd of February. It seemed from the submissions that Mr. Ansell was making, and I'll address everyone together, that Mr. Ansell seemed to be saying he hadn't really read it or didn't understand, or certainly not very clear about what was being run at trial today.
Yes.
That can't be the case, when it was filed on the 23rd of February pursuant to a grant of leave by Her Honor. It's made very clear in the proposed amended originating motion that the relief that's being sought against Ms. Shu and Mr. Kuksal is almost entirely not wholly, but almost entirely in the same form that the original motion originally filed back on the 7th of October 2022 is.
Yes. Yes.
Now, I don't accept that the originating motion needs in some way to particularize a reference to the uniform law.
But when the originating motion was filed in its original form, the injunction was expressed to be an order, preventing Ms. Shu from obstructing Mr. Rapke.
Yes.
Including by sending those emails.
Yes.
So it seems fair enough to me for her to have understood that as the complaint being that the sending of those emails was unlawful or improper, to use a more different term, because doing so would obstruct Mr. Rapke.
Yes.
Now those injunctions are sought to be maintained for a different reason.
Yes.
And Ms. Shu tells me, and it's consistent with the transcript she's taken to me, that she didn't know that it was being asserted that the sending of the emails amounted to a contravention of S11 of the uniform law until she received your submission. But that's plausible, isn't it?
Well, whether she knew it amounted to a contravention of the uniform law, I think, Your Honor, she had put it as being that wasn't how she had understood what to not know about the case.
What she was saying, look, the case against me was always that I shouldn't send emails, because doing so would obstruct Mr. Rapke.
Obstruct? Yes.
Mr. Rapke's not here anymore. Why are they still trying to get this injunction from me? And I think it's probably fair to say that the first time that was made clear to her was when she got the submission.
I accept that would be fair, Your Honor. The issue, though, is that Ms. Shu has sought to create some sort of conclusion, reasoning inferentially, that because I, as I admitted, and apologized, was not able to answer that question, because at that time I was only briefed for the directions hearing, bullied to the directions hearing.
No, I'm not going to draw an inference that it's been invented.
No, yes, and that's the point, that until that point, that somehow she reasons inferentially that the board didn't know what its case was. What novel?
No, I'm not interested about that. I'm going to prepare to assume that the board knew that the case was a breach of S11, but Ms. Shu didn't.
Yes. We then have the affidavits that are filed in accordance with Your Honor's orders. Quackant.
Yes.
And that they're served, so the first one is Mr. Anstey's and then Ms. Cherry's affidavit, which outline those materials that are sought to be led against each of the defendants. So there is the evidence that is.
So which affidavit do you want me to look at?
Well, if Your Honor looks at, for example, the affidavit of Mr. Cherry that's affirmed on the 21st of June.
Ms. Cherry, yes.
So, for example, at paragraph 9, she gives evidence about having received emails from the law practice domains, email domains from those following accounts.
Yes.
And then she gives that further evidence specifically in relation to the email domain of Peter at ari.legal.com.au.
Yes.
And then it continues over the page in relation to documents of a legal character, which are very much directed at, in my submission, evidence that supports contraventions, or that would form that basis for the grant of injunctive relief under 447.
But there's no identification there of it being said that the sending of these emails is a representation of whatever the wording of S11 is.
No, yes, an entitlement to practice. No, I accept that those words are not used. However, it's very clear, firstly, that the evidence has been disclosed significantly in advance to the filing of the submissions.
Yes, and the evidence doesn't seem to be particularly controversial in the sense that it's what you make of the evidence that seems to be an issue. The evidential is essentially the production of documents.
Indeed, that's right. And it is within that production of documents that are clearly in my submission, if they were to be read, that it demonstrates what it is sought to be put against the defendants by way of that evidence.
Yes. Well, it's clear, Ms. Xu, everyone's known since the 21st of June or thereabouts, that the evidence the board relied on was these communications.
Yes.
All right. But why do you say that means that Ms. Xu should have known then that it was going to be said that those communications, that it was not in circumstances where communications of that type had previously been relied in support of an allegation that she was impeding the work of Mr. Rapke? How is she to know that now it was being contended that they supported a conclusion that she was in breach of S11 of the Uniform Law?
I accept, Your Honor, that it was not until the written submissions were filed that was particularly put in writing.
Yes.
That's certainly accepted.
Does that not create a difficulty then, when you've got… the other thing with Ms. Xu is there are interim injunctions in place at the moment.
Yes.
So Mr. Ansell's different.
And I can address that in particular, because that's also a concern.
So if she says to me, I take the matter seriously, I just didn't appreciate what I had to deal with until a week ago. I want some more time to think about it. It's difficult, isn't it, for me to say, I'm not going to give it to you?
Well, it's difficult. Firstly, it might be difficult for Your Honor to say, I'll give you 3 months in response.
Yes, I don't need to hear you on the argument that adjournment is needed to allow the addition of the Attorney General or the Commissioner.
Thank you, Your Honor. The issue that I take is the manner as well, is the manner in which this application for an adjournment has been brought, that is, the very late notice. If Ms. Xu had indicated on receipt on the 10th of July in relation to, I need that further time, then that may have been the case. I just will pull up that email because so it was on the 26th of June, and this is the email that Ms. Xu referred to in relation to seeking extensions for filing deadlines in relation to orders made by Your Honor on the 4th of June.
But that's before she's received your submissions.
Indeed, but there's no further application or separate application seeking an application to adjourn or vacate this trial date.
Yes, until this morning.
Until this morning?
Yes. Well, she can be criticized for that, but is that reason to deny it?
It is when seen in combination of other matters, such as whether will she do with that time.
The most powerful point she made, it struck me, is when I said what will you do with your time is, in essence, I'm not sure. I have to think about it. I haven't had time to work out how this section operates and what I should be arguing about it.
Yes. It is a particularly I do accept, Your Honor, and I do accept particularly for, as Ms. Xu says, as a self-represented litigant, someone whose English may not be her second language. I'm not disputing that she might need time, but…
And I'm not persuaded by her English being a problem.
Then we're still in a situation where no communications were sent post-receipt of my client's submissions, no application made to vacate this trial date. When seen and the way in which the applications are being put to Your Honor, the defendants are supportive of each other's applications, and the way in which they're put in almost a combined manner, it really has a tenor or a tone that this is an attempt to derail the trial date, because on one view, and this is where some of the inconsistencies come out, on one view Mr. Kuchsel has said something to Your Honor about being unable to be prepared or to prepare for the trial when we have comments from Mr.
Sorry, Your Honor, if there's going to be allegations put against me.
Keep Mr. Kuchsel on mute, please.
When we have comments from Mr. Ansell saying that they have been working on matters progressively over the last month, and I accept that Mr. Ansell has said separate comments about his reliance on Mr. Kuchsel for the presentation of his case for assistance with that. But Ms. Xu has also said or made comments about preparing or having prepared the case together, coup or may. So it's wholly unclear about whether they indeed have or have not. It's inconsistent, and it demonstrates attempts to derail this trial date, which has been set down for some time, and attempts clearly at the last moment to vacate the trial date when any application, any communication could have been made after receipt of the submissions.
Yes. What difference would it have made, though, if she had floated this argument at the beginning of this week, rather than at the end of the week?
It would have made significant difference in terms of the preparation, in terms of the wastage of this court's resources. The application.
Well, only if they granted the adjournment. I would have still had to have listened to it, and unless it was done by consent.
Or indeed it could have been listed at another point.
I should, just for the purpose of the transcript, I've just been informed that Mr. Cooksall has left the Zoom meeting. Anyway.
The other issues, yes. I think that's probably as far as I can take it in relation to responding to those matters. There are some other matters to respond to.
What do you say about the possibility of determining the S11 breaches alleged against Mr. Ansell tomorrow or today, and putting the the S10 breaches by Mr. Ansell allegations now, and putting the S11 ones against Ms. Shu and Mr. Cooksall off to another date?
I think I would have to just seek potentially a very brief adjournment to confirm instructions, because at this stage, I don't have instructions, if that's still my case.
Yes, I'd let you do that. I want to make some...
Can I?
Just something about some general comment. At first blush, your case against Mr. Ansell is strong, right? At first blush, and its high point seems to be the bill of costs that he's prepared where he says that he was paid $18,000, that erudite legal or whatever charged $18,000 odd in costs to Mr. Cooksall at a time when he had a practicing certificate. Now, if that is what I end up concluding occurred and the like, it might be quite subject to what Mr. Ansell says, pretty straightforward. Like, his only argument against that might be the legal argument that doesn't matter if he didn't have a practicing certificate, because he might win his case to say that they were wrong not to extend it.
Yes.
The case against Mr. Cooksall and Ms. Shu is much more complicated, is it not? Because you have to elevate, effectively, the mere use of a domain name with a legal identification into it as a breach of S11. Mr. Cooksall's back.
Yes.
I might just, Mr. Cooksall, I was told that you left the Zoom. He might be frozen.
Hello.
Mr. Cooksall, you're back. You haven't missed much. I'm still talking to Mr. McAuliffe. So if the case against Mr. Ansell can be confined to the S10 claim, that is, not purporting to be able to engage as legal practice, but actually engaging in legal practice as someone without a practicing certificate. So that would seem to be a manageable, confined sort of argument.
Yes.
The case against Ms. Shu and Mr. Cooksall is, it seems to me at first blush and there's preliminary views, a much more difficult case because you are seeking to elevate, effectively, and this might be underselling your point, the mere use of email addresses, which include references to law firms, as somebody representing an ability to engage in a legal practice. The two cases you've cited in your submissions, one of which was mine of NIDA and the other one of Jensen of Justice Gardner, both concern situations where the people sending the communications were not themselves parties to the proceeding but were purporting to represent others. Now, I know you've got arguments about, was Mr. Cooksall representing his for Mr. Ansell or whatever and the other, but what I'm saying at the end of the day is that's a reasonably complicated decision, and one that would, at first blush, be something capable of being dealt with separately, to the more straightforward case against Mr. Ansell.
Yes, I certainly accept it would be capable of being dealt with separately.
Well, Mr. Cooksall, I'm not sure exactly when you left the Zoom. I'm going to, in a moment perhaps, give Mr. McAuliffe a moment to get instructions on his client's view in relation to me.
Your Honor, I haven't been heard.
If you just give me a moment, Mr. Cooksall, I'm going to give him an opportunity to do that, to get his instructions on that, and I'm conscious, and have always been conscious, that this was something I raised with Mr. Ansell, and not with you. So I am conscious that you have not been heard on the matter yet.
I should be heard before. I should be heard just like everybody else was heard. There's no reason to discriminate.
Please put Mr. Cooksall on mute. Mr. Cooksall, as was readily apparent from what I said, I was going to return to you after I've heard from Mr. McAuliffe on this point. Mr. McAuliffe, what do you say about, there are a number of reasons put forward for the adjournment. One was the one we've been dealing with, that Ms. Shaw emphasized.
Yes.
What do I do about the medical, it can't be called medical evidence, but the medical material? Is that something that, what's your submission on that?
My submission on that is that Your Honor would not be seeking to place much weight or any weight on it at all. It lacks in my submission any useful detail about the nature of the medical issue, the extent of it.
Yes.
Its effect on Mr. Cooksall, its effect on, I'm just talking only here about this physical issue in relation to the ear issue, the effect on his ability to prepare for today, or to participate in the trial. These medical certificates don't refer to any other condition, physical, mental health-wise. Mr. Kuksal has not made available his doctor to give evidence in support of these certificates. I understand that he has provided an explanation by email.
That's his doctors are not working.
Not working today.
Which is different.
Yes. The other issues are certainly a similar issue that I raise against Mr. Kuksal with his medical certificates is that his first medical certificate is dated the 21st of July, and that refers, well, firstly the certificate itself refers to his medical condition, making him unavailable to present for work on 22 to the 23rd of July. And then the covering letter says that, on his request for his court hearing to be adjourned, that doctor would support such a request. The second document, the medical certificate is dated, was completed on the 28th, and then covers 29 to the 1st of August. And again the doctor supports a request for a court hearing to be adjourned. There's no information, detail or explanation as to that opinion as to why the doctor would support such a request in relation to this ear health issue. It is entirely, in my submission, unsatisfactory and does not assist the court. But the point about the dates is clearly, if there had been or there is a health issue that was known to Mr. Kuksal since at least the 21st of July, and we have a very last-minute application to adjourn the hearing, so vacating his trial date.
Yes, all right. If I were persuaded by what Ms. Shu said, and formed a view that it would be unfair to proceed against her today, Mr. Kuksal, would it be possible for me to to separate Ms. Shu and Mr. Kuksal? Or my preliminary view is that the allegations against those two are so intertwined that it would be difficult to do so.
Yes. It might. It would be difficult, it might be possible.
That's something else. If you're going to get instructions on, I'd get instructions on it. Thanks.
Yes, Your Honor.
Mr. Kuksal, I'm going to stand the matter down just a couple of minutes to let Mr. McAuliffe get some instructions on his client's position, on the prospect of proceeding with the application against Mr. Ansell, without proceeding at the same time in the application against you and Ms. Kwanz. When I've come back from that, I will ask you what you want to say on that point. Please stand the matter down temporarily. Mr. McAuliffe, what are your instructions?
Your Honor, I just note that I don't think I see Mr. Kuksal online.
He hasn't joined yet.
My instructions are that we would seek to split our case, the board's case, against Mr. Ansell, and proceed in relation to that sole issue against Mr. Ansell, to use this time that we have available.
Yes.
In relation to Ms. Zhu, if Your Honor does grant that adjournment application made by her, then in my submission, it should follow. Given the way in which, I think Mr. Kuksal has just joined, Fiara $2.
Yes. Yes.
I can repeat myself if that.
No, it's all right. I'll just say the board says that if I'm persuaded by what Ms. Shu has said, then they would wish to proceed against Mr. Ansell in the meantime. Yes.
And if Your Honor grants Ms. Zhu's application to vacate the trial against her, then it should follow, or Mr. Kuksal's should follow, given the way in which the case against the two of them are intertwined.
Yes, I see the sense in that. Mr. Kuksal, what do you have to say on the prospect of hearing the argument against Mr. Ansell separately, and in advance of hearing the argument against you and Ms. Shu?
Well, I'm strong for a number of reasons, but I want to foreshadow beforehand that I want to address a few matters to preserve my rights to argue later that I was not given an.
I want you to address the.
Yes, but Your Honor, I just want to clarify a few things because I.
Put Mr. Kuksal on mute, please. Mr. Kuksal, I've asked you a question. I expect you to answer it. When you've answered it, if there's stuff that you feel like you need to put on the record to protect your position, we'll deal with that then. I've asked you and I expect an answer. You don't have to answer it if you don't want to, but I'm inviting you to express a view or put a position on the prospect that I hear the argument against Mr. Ansell, in advance of hearing the argument against you and Miss Lam. Yes, take him off mute.
So I take it that Your Honor is giving an assurance that I would be heard in relation to the other matters after I'm heard in relation to the questions that Your Honor is asking me.
I'm asking you to answer my question.
Okay. But I simply
stand the matter down for another 5 minutes to let Mr. Kuksal try to reconnect. Mr. Kuksal, you were saying? Mr. Kuksal?
Hello, can you hear me?
Yes, we can.
Am I audible?
Yes, you are.
Am I audible? Sorry?
Yes, you are. Now you're not.
Your Honor, could you say something so I can.
Yes. You've just come in loud and clear. Can you hear me?
Yes, I can hear you.
Thank you.
Thank you. So, what I was saying is that I simply wish to identify all the things that I want to address, because there were allegations raised about me trying to mislead the court or misrepresent the extent of my illness, and I wish to address those issues. I also wish to address issues around the fact that all the things that Misra had raised, I had raised the exact same things. But when I had raised those things, Your Honor had reacted much differently than what Miss Yu received in terms of reaction.
Mr. Kuksal. Mr. Kuksal, it's 1:10. I'm going to give you 10 minutes to speak, and tell me what you want to say.
Well, Your Honor, that's patently unfair, but fairly typical for these proceedings. The first thing is that in asking questions of the sort that Your Honor has, it's a qualm that in bringing and obtaining the proceedings. So,
Mr. Kuksal, you've gone quiet again.
sorry,
This is unsatisfactory, Mr. Kuksal.
Your Honor, it's not my connection that is the problem.
Yes. Well, we'll push on.
I'm not sure, okay. So, Your Honor, I think it was implicit in the manner in which Your Honor was asking questions that the defendants were required to presume that the other species' actions were sensible, and that if they had sought some relief, they were justified in seeking it, and therefore we should have prepared whatever we could. Our position has always been that they did not have a basis to seek the relief that they were seeking, and therefore they could not identify the provisions that they were relying upon. And when they identified those provisions at the last minute, our ability to prepare a defense was prejudiced. Now, in relation to how the matter is interlinked between Mr. Ansell and me, and Miss Xu, firstly, until the 18th of July, we had always relied on the argument of abuse of process as the main argument that we were preparing for. All of us have been ambushed as of the 18th of July, because, as Your Honor has correctly noted, Mr. Ansell's main argument has always been that the court has to first determine whether they acted in good faith or not, whether their jurisdiction to take the action that they were taking was invoked. Now, in saying that, Mr. Ansell is entitled to practice. There is no admission that he has in fact practiced. And I note that the manner in which Your Honor was questioning Mr. Ansell was a breach of his right against self-incrimination. And this is how it affects me directly. Section 14 of the Uniform Law essentially provides immunity to lay people employed by legal practices. So Your Honor cannot even find against me, or Ms. Xu, in respect of any allegations under the Uniform Law, unless there is a finding against Mr. Ansell. So it is absolutely in my interest that the case against Mr. Ansell be dismissed, and I'm absolutely not prepared to allow Mr. Ansell to proceed on his own. I am aware that it was my part of the work to compile the legal submissions and authorities. Mr. Ansell has had constant interactions and discussions with me, but he's not good with the preparation of documents. He is very technologically challenged, so he's incapable of compiling and presenting the data that needs to be done. When he was working as a sole practitioner, he was relying on other people to assist him with that. And he does not have access to any of the authorities or the sections, which is material that has always been lodged through my Redcrest account, as a matter of fact. Now, the only thing that Mr. Ansell has really prepared somewhat independently is affidavit material, and the affidavit material is such that he simply exhibits documents. They are documents that either embed to court proceedings, or they're documents that are email exchanges. There are very few instances of which he has given personal account of matters, and the instances in which he's given personal account of matters, he's prepared independently. But the fact that he has had involvement in the preparation of documentary, or in the presentation of documentary evidence, is no answer to the question that he will be prejudiced if this proceeding continues in the current manner, because he had no idea that he would have to argue the case, the legal arguments of the case without any help.
I'm more interested in what your prejudice is, Mr. Kuksal.
There.
You referred to...
But this is my prejudice. If there's a finding against him that directly prejudices me.
You referred to S14 of the Uniform Law.
If this might be against it.
Is that right? Section 14 of the Uniform Law?
That's right, yeah. So it's 14 if so, Your Honor. There's two prejudices that arise in my respect. The first prejudice is S14, and things that link with that. The second prejudice is that I own the intellectual property that they're trying to limit the use of. I'm also going to be financially affected in relation to any interference in Mr. Ansell's ability to use email addresses. So I directly financially benefit from the operation of the business, and any interference to the operation will ultimately be upgrade of direct and transferable prejudice. They have not identified the public interest consideration that will be affected adversely in this instance. No one has come up and said that Mr. Ansell is providing legal services. and it is causing the material prejudice to a specific person. We're only seeking an adjournment, and the considerations in relation to an adjournment is whether there is a countervailing prejudice on the other side. But under no circumstance will I permit Mr. Ansell to be the subject of continued proceedings without me, if I have anything to say about it, because it will directly prejudice my interests. Now I also want to address a few other things. This is in relation to the argument about, we should have always known what they were seeking. Besides what I've previously said, which is that it's always been our argument that there was an abusive process, and they were basically looking at things to grasp. Your Honor had himself on the FUGF in February. This was on the FUGF, if I may just bring up the FUGF. So, in February this year, the 19th of February, Your Honor had agreed with me that an abuse of process determination would have to be made in respect of this proceeding. This was when the question of the costs was being determined, if Your Honor remembers. Does Your Honor require me to take him to the specific lines of the transcript?
I can't remember what was said on the 19th of February 2024 just sitting here, Mr. Kuksal.
Okay, so Your Honor, if I'm going to refer to the specific lines then, do you have the transcript in front of you?
I can get it. I don't understand why you're taking me to it.
Because we have been ambushed, and we have been ambushed as of the 18th of July. Our case has always been that the proceeding has been commenced as an abuse of the court process, and the court has to first determine the validity of the evidence and the validity of the actions taken by the LSBC. Your Honor has agreed with me about that, and it was only when
the transcript of on the 18th of February.
The 19th of February.
In this proceeding?
Yes.
Yes, I have the transcript of the 19th of February.
Okay, so Your Honor, if you go to P59, where the ruling starts.
Yes. No, I don't have 59. I'll find it.
That's the ruling. That's the ruling.
Yes. I have that now.
Okay, now I take Your Honor. So that's where the ruling starts, and I take Your Honor to P62. This is part of the ruling, 914. Should I make the costs order at all, Mr. Kuksal, that you should not be ordered pay, on the grounds that a proceeding was immediately commenced, so on and so forth. So there were two grounds that were raised. One was that the proceeding itself was commenced imminently. That was one of the abuse of process grounds, and Your Honor clearly indicated that that is something that Your Honor would have to decide. Whilst indicating that it could not be, even if the proceeding was commenced irregularly, there may be the possibility of that the court could still permit the LSB to fix the irregularity. That still needs to be decided by this court.
Sorry. Where do you say I accepted your argument that the first thing that had to be determined was whether the closest I can pick it up, just looking at it, is P64, lines 14 to 16. Is that what you're referring to?
Well, this is part of that, yes, but have to read, I'm going to.
Mr. Kuksal, you said that I agreed with your proposition.
Absolutely. It's.
I can't remember. Well, you take me to the page and line where I did so.
Okay, so I'm going to start reading from line 25, P62. He submitted that the validity of the proceedings, including that it was initiated as part of a conspiracy of unlawful conduct directed at him by the board and Victoria Police, and those people in those organizations have to be decided before any course could be ordered. That I need to first determine whether there is a proceeding. The other defendants adopted these submissions. I do not accept these submissions for a number of reasons. First, Rule 4.05b provides that a proceeding here.
Mr. Kuksal, don't just read it out to me. You made an assertion. Take me to the passage that makes good the assertion.
Yes.
Or withdraw the assertion.
So the inference that arises from those passages, what Your Honor is saying is that, what Your Honor is effectively saying is this: that I submitted that the court's orders should not be made because the validity of the proceedings needs to be first determined. The validity of the proceedings was challenged on two grounds at that stage, broadly speaking. Two main grounds. There were others as well, but the two main grounds were, 1. There was a technical defect in the commencement of the proceeding in relation to the specific provision that was involved, and the manner in which it was invoked. The second element of the first technical defect was whether or not there was a valid affidavit in support of the originating motion. And then the second main argument was whether the proceeding was commenced as part of a public mischief to the course of justice, effectively speaking. What Your Honor determined at that point was that it was unnecessary for the court to defer the making of a costs order until the determination of those two things because, 1, the cost order was in relation to costs that were incurred because of steps that were taken, and those steps were taken by us. And even if the proceedings had been commenced improperly, even if that were the case, that doesn't change the fact that we took those steps which led them to incur those costs. That was Your Honor's argument effectively. The second thing was that because, ultimately, those costs were attributable to our conscious conduct, the determination of the abuse process-related issues should not hold up the making of a cost order. But it was implicit in there, and there were specific parts where Your Honor actually stated that Your Honor would determine that at a later stage, about the abuse of process matter. And Your Honor, we've actually raised this on affidavit as well in Your Honor's recusal previously, and it has not been addressed by. In fact, I refer Your Honor to the email that was sent on the 26th of June to Your Honor, which Your Honor treated as evidence in his judgment. And in that particular,
Look, Mr. Kuksal, it's 1.27. I am going to adjourn at 1.35, and you've got until 1.35 to finish what you want to say.
well, Your Honor, I'm not repeating myself. I'm raising new arguments, including the transcript. Nothing that I'm saying is superfluous. If you want to arbitrarily cut me off, that's up to you. But the point is that the way in which this matter is proceeding is completely haphazard. It keeps changing randomly, and Your Honor keeps shifting the base upon which the arguments are being made, depending on the weakness of the other side's case, and Your Honor's need to prevent that from them losing in the proceeding. We were explicitly promised that the abuse of process arguments would be decided at a later stage. The abuse of process arguments cannot be decided after the proceeding is over. Mr. Ansell's position has always been that they did not have jurisdiction, and that the proceeding was started as an abuse of process. In fact, he has said that on affidavit repeatedly. Now that's where all of us were presenting the same date, that the LSBC had no basis to intervene, and the intervention was sought to prejudice or sabotage my legal representation. I refer the court to a couple of a few authorities in this respect directly. So firstly, I refer to this is Accident Claims Lawyers Pty Limited versus Legal Practice Board, 2024, WASC 249. This is exactly on the point, and it sets out what the objectives of the law are, the circumstances in which the law can intervene, and if there is a jurisdictional error, basically their steps have no effect whatsoever. It's the first one. Then I refer the court to Dennis. I'm just bringing up the Dennis v. Council of the Law Society of New South Wales, 2014, NSWSC 1487. Again, in this proceeding, an investigator was appointed. There were steps taken against the legal director, and those steps were found to have been taken without jurisdiction, and basically, the matter was dismissed. And there's Cahill v. Legal Services Board, Commissioner of Victoria Legal Services, 2017, VSC 177. In this particular instance, the Commissioner failed to inform the practitioner of the complaint before taking action pursuant to complaint. This was Justice Keir. He ruled that the failure to inform the practitioner of the complaint invalidated the subsequent actions. Board appealed. The Court of Appeal agreed with His Honour. Then I referred to DPP v. Edwards. Now this is particularly relevant, because it contrasts starkly with the statements in Your Honour's judgment about the public policy issue in the proceeding. So, I'm reading from paragraph 40 of DPP v. Edwards, 2012, VSCA 293. I believe this was a unanimous decision of the Court of Appeal of Victoria. From a practical, and also a policy viewpoint, the principle may be thought to be somewhat unsatisfactory. This is the principle that administrative decisions are nullities of law if they're made in jurisdictional error, and anyone can ignore them without consequence. Its undesirable consequences are obvious. It potentially creates uncertainty for parties and other affected persons in the conduct of their affairs in reliance on an order. First, the principle means that an inferior court order is not only able to be set aside on appeal or a judicial review, but that they lack legal effectiveness ab initio. Thus, for example, in a particular instance, a person to whom the order is directed may be able to disregard it with impunity. Secondly, the principle may open an inferior court order to collateral challenge outside of the time limits for judicial review. The policy advantages of treating a decision in excess of jurisdiction as a nullity are less obvious for inferior court orders than for administrative decisions. Unlike administrative decision-makers, inferior courts are constituted by judicial officers, and so on and so forth. They continue. In fact, what they were saying is that this applies for inferior courts as well as administrative decision-makers, and with administrative decision-makers it may be less problematic. With inferior courts it is far more problematic, and this is how they conclude the discussion. This is paragraph 42, so 40 to 42 of Edwards. In my view, there is much to be said for the proposition that orderly administration of justice would be enhanced if inferior court orders were valid and effective until set aside. However, the contrary position is firmly entrenched in Australian law. It is recognized in the decisions of the High Court that are binding on this court. Furthermore, as a matter of comedy, it is not possible to disregard the decisions of other intermediate appellate courts. If the position is to be reconsidered, it could only be done by the High Court. Now, the High Court also addressed this issue as recently as 2023, where now Chief Justice Gageler had the following to say. This is Stanley v. DPP. The citation is 2023, HCA 3. This is paragraph 14. Within a system of government in which power to effect a legal right or interest is limited to that authorized by law, there is utility in having a standardized means of expressing a conclusion that a purported exercise of power pursuant to an authority conferred by law exceeds the limits of that authority. His Honor clarifies that that is jurisdictional error. Then, in paragraph 15, His Honor clarifies.
Mr. Kuchsel, none of what you're saying is, I think, helping me, so…
The point is, Your Honor, that we had prepared the case on the basis that the court, Your Honor, if Your Honor, were deciding the issue, would first determine whether the board had made a jurisdictional error or not. Because if they had made a jurisdictional error, then…
Okay, I understand that. I understand your point.
And then Your Honor basically pulled the rug from underneath our feet on the 8th of July when Your Honor fundamentally changed the manner in which the case was to proceed.
Okay, thanks Mr. Kuchsel.
Now on the 24th of June was the first time… No, Your Honor, let me clarify this. On the 24th of June was the first time that Your Honor gave any indication that that is how the argument may proceed, because in February, Your Honor had made it very clear, and this is reflected in the transcript, that Your Honor would decide the abuse of process, but would decide it at a later stage. Now, when Your Honor first indicated on the 24th of June that the court may limit the consideration of the evidence,
yes,
about that jurisdictional error was no longer arguable, we thought that that was on account of the fact that Your Honor had not considered all of the arguments, because Your Honor had said that without taking any submissions from us about how the matter ought to proceed.
All right.
That is why we raised the issue on the 10th of July.
All right. Thanks, Mr. Kuchsel.
Now, I also need to clarify the issue about the medical, Your Honor. I also wait to quickly address the medical stuff, because there have been things that have been said, and it's prejudicial to me.
Yes.
So firstly, I'm here participating in the proceeding. I've made it very clear that the ear issue has nothing to do with my capacity to hear. I've been very upfront about what I can and what I cannot do. The medical details in the certificate are insufficient, because that is standard. I provided dozens of medical certificates, because I participated in hundreds of proceedings over the last few years, and there has never been an issue of the sort.
Yes.
Now I'm here to give evidence. There is no issue about my credibility, and I have never indicated that I am physically prevented from doing stuff altogether.
Yes.
What I have indicated is I have been severely restricted, or my ability has been severely compromised. And on some occasions it was completely debilitating, the inconvenience that I was experiencing, and on account of that, the preparation of documents has been affected. Now I had seen, to Your Honor, that we're involved in dozens of proceedings, and that we had to simultaneously manage that workload to…
All right. Thanks, Mr. Kuchsel.
Essentially, it can't…
I'm going to put Mr. Kuchsel on mute. I take the view that Mr. Kuchsel has had plenty of opportunity to present his submissions. In this matter, I am going to make the following orders. I'll publish reasons in due course. The application for the relief sought against Mr. Ansell, the second defendant, in paragraph 3 of the amended originating motion, let me just bring that up, filed the 23rd of February 2024, be adjourned to be heard on Monday the 5th of August 2024. The applications for relief sought against the defendants in paragraph 2 of the amended originating motion be adjourned to Tuesday the 20th of August 2024. The defendants file and serve any submission in relation to paragraph 2 of the amended originating motion of no more than 20 pages on or before 4 p.m. on Friday the 16th of August 2024, and I will reserve the costs of today. I will provide reasons in due course. So what I've ordered, Mr. Ansell, is I'm going to hear on Monday the application for the injunction that you be restrained from engaging in a legal practice without a practicing certificate.
Yes, Your Honor. May I just make a couple of…
I'm going to hear the balance of the application on the 20th, which is in a Tuesday of a few weeks' time.
Your Honor, I did rise to my feet just prior to the Mr. Kuchsel finishing, just to make a couple of major points, as far as I'm concerned, just in relation to Your Honor. Firstly, I rose to my feet to indicate to the court that there was a conversation was about the fact that I didn't have a practicing certificate on the 7th of October, when these proceedings were issued, but the fact of the matter is I did have a practicing certificate at that time. The second matter is in relation to myself, Your Honor, in that I have quite profound hearing loss. I do wear dual hearing aids. The advantage I have of appearing with Ms. Shu and Mr. Kuksal is that if things are missed and I miss them in what's being said, that they then can clarify those issues. I would say this, Your Honor, that I would, given the circumstance of having to appear in this matter and separately, that I would need to probably brief counsel to assist me.
I've adjourned it until Monday, Mr. Ansell.
They're quite significant issues, Your Honor.
Mr. Ansell, you have known about this for a long time.
Well, Your Honor, I think
You have not had illness.
And I think Mr. Kuksal had also explained to Your Honor the matter and substance of this matter has changed as of July.
Mr. Ansell, I've made my decision.
Yes, Your Honor.
And I'll say in my reasons and as emerged from our discussion, I think the position in relation to you engaging in practice without a practicing certificate was an issue you were on notice about at all times.
Well, yes, Your Honor. Well.
All right, so adjourn.
Your Honor, I apologize to interrupt, but can I rise just to raise an issue just in relation to the second part of Your Honor's orders, just as to the 20th of August? Yedivet, we rate again.
Yes.
One of my witnesses, Ms. DeCesare, is overseas on pre-booked leave. However, I'm just seeking instructions about whether, because her evidence is, essentially, the production of documents, about whether there could be another deponent in an affidavit filed. I can indicate that to, essentially, produce the same materials, nothing new. And if that can be the case, then I would just seek liberty to apply for Your Honor to be able to file that affidavit.
Sworn by somebody else who would be available for cross-examination if required.
Indeed, yes.
All right, thanks for raising that. We'll deal with that in due course. Adjourn the court until...
Sorry, Your Honor. Just about a procedural issue there is in respect of the documentation. I haven't received any of the documentation.
What documentation?
Subject to the affidavits that I think Mr. McAuliffe has raised.
It's all been served.
Okay.
First time you've said, Mr. Ansell, that you didn't have any of the documents.
Yes. No, Your Honor,
We'll adjourn the court to the 10.30 on Monday.